All right, visitation or family time. How many of you feel as though the children and families in your communities get enough time together once the children are pulled? There's some, yeah. Okay. Well, I tell you, I don't either, but we're doing pretty good, so you're probably not going to satisfy me on this one. But let's talk a little bit about visitation or family time. Visitation is a critical part of case planning by statute. We have to have a reasonable visitation schedule. We talked about this earlier, that allows the parents to maintain meaningful contact with the child through in-person visits, phone contact, and letters. What we're going to talk about, that's the law. What we're going to talk about more today is the protocol that we developed. We're not going to talk about visitation policy. Number one, I don't really know it. I don't care about it because I know it's inadequate. So we're going to talk about the visitation protocol. The Visitation Protocol was a project of the Georgia Court Improvement Initiative, what we call it now. Back then we were the Child Placement Project. It was the same organization, which it all fell within the Committee on Justice for Children. Well, actually, I guess the Court Improvement Initiative has always been called that. Well, and there was the model courts at one time. But the Committee on Justice for Children used to be called the Child Placement Project, and it was called that at the time we developed the protocol. You have several pieces of material about the Visitation Protocol in the handouts. I will tell you that the Committee on Justice for Children just yesterday created a website, thevisitationprotocol.org. And you can go there and get the entire report. I decided to save some trees and not hand it out today. It's fairly lengthy. And you can download it on that website, visitationprotocol.org. Also, there's some PowerPoint presentations. A few years ago, a number of us did some presentations, a large one at Georgia State. This was in cooperation with the Department of Family and Children Services. We did a large presentation at Georgia State on the Visitation Protocol, and that was actually videotaped, and you can see that on the website. And then we also did those at either 3 or 4 sites around the state. I would tell you that when I talk about this issue too, a lot of times I like to bring my child welfare administrator from the local agency with me. Do we have any agency people here today? Got a few. And I know we have some SAGs here today as well. And I do that because when we talk about the visitation protocol in a lot of communities, most communities, we get challenged on how you can do it, how you get it done. So I like to bring my folks with me. It didn't work today. Basically what happened is in around 2003 probably, then I was at a meeting of the Board of Trustees and the National Council, and the issue of visitation came up. And Judge Tom Zampino, a great guy and very committed judge, kind of challenged everybody on visitation and basically said, this is just not right. And as judges, we have a responsibility to do something about it. And so I came back home, talked to Michelle and others at Committee on Justice for Children about it, and they agreed to support the development of a protocol. We brought together a multidisciplinary work group from local, state, and national organizations. The National Council sent in some judges and some staff. National CASA had representatives there from National CASA, from their office, at both the judge and staff. State DFACS was represented at various levels, case manager, supervisor, state level policymakers. Child's attorneys, parents' attorneys, guardians ad litem, service providers. We had, I think, either 3 or 4 psychologists involved in the group. Only one that was there as a psychologist. The others were there in other roles. We did have a lead, if you want to call it that, lead child psychologist that did a lot of research for us and a lot of teaching to us to educate us on developmental needs of children and to kind of say grace over the piece when it was finished. It is a work in progress. We had those meetings. We agreed on the draft that you have that's online with a couple of exceptions I'll talk about today. Later on, we were unable to bring the work group back together to do any more work on that basic piece. But I took the liberty, as one of the authors of the original draft, to insert a couple of things we do in Troup County, but they're noted as such. some developments that came about after the group had met. It is still very much a work in progress. We've learned a lot about it. I've presented on it in Georgia and nationally. I've had people sending emails asking for the materials, and we send them out. And then sometimes I'll be in another state, and someone will come up and talk to me about what they've done in response to that. There's other great work going on out there in this area by other organizations, both national, state, and local. So it's not just what we have done, and certainly not about what I've done, but a lot of people are really committed to this area. The work is important. Visitation, family time is so important to these families. I couldn't imagine what it's like being removed from my parents and the circumstances where many of these children are removed. In most of these cases, in a lot of these cases, the children are removed without an opportunity of actually speaking to their parents. They may be at school and they've made a disclosure. DFACS law enforcement shows up and they go off to foster care without even seeing their parents. A lot of times they're removed in very traumatic circumstances from their parents, in the very presence of their parents, which has to be traumatizing for those kids. I kind of remember summer camp myself, and I was a mama's boy, and we were supposed to go off to Camp Viola. And I know my mother told me one thing. She said, first time I've really been off from home. And she said, if you get there and don't like it, you call me and I'll send somebody to come get you. My mother learned how to drive in her 40s, so she couldn't come get me. And I didn't like it, and I called my mother. She sent somebody to come get me. I can't imagine what these kids go through, but we all know how important it is. And research shows us also that it drives permanency. There's also some research. There's a program going on in, I want to say, Ohio, where they have way more visitation or family time than we have in this protocol. And in a lot of those cases, it drives something other than permanency because the parents have a lot of contact and actually have a great opportunity to demonstrate that they can't parent. But it's a work in progress, and we solicit your input. We use the term family time. I still use visitation a lot because it's in Shines that way, and because it's the name of the project, Visitation Protocol Protocol. But it doesn't really describe the time that families need together. To me, when you talk about visitation, you go out to work camp on Sunday to visit your cousin or your uncle, or you go to the hospital to visit your sick friend or relative out there. And that's not really what we're talking about in some sterile environment like that. We're talking about family time, time that families can spend together as a family. When I talked earlier about the Nebraska thing, I talked about allowing children to be children and families to be families to the extent that we can. That bleeds over into this discussion on family time as well. The family time should be frequent, consistent, as family-like as possible. In the initial work we've done on this, we focused on duration and frequency and did not have an opportunity yet to get into the quality visitation, although a lot of really good work's being done on that as well. The goals of the project were to reach a consensus for minimum family time. We spent a lot of time deciding what to call it. We came up with family time. We spent even more time deciding what to call a piece of this, which is minimum family time, standards, aspirational goals. I like standards because I think they should be minimum standards, but we couldn't agree on that. But we did ultimately reach a consensus for minimum family time. We call them default provisions. We'll get to that in a little while. Identify innovative practices, find out things going on around the country and the state. Identify the roles of various persons and agencies with reference to visitation. And very importantly, we thought it was important to develop a decision model to ensure that all relevant factors are considered and properly weighed in setting family time. Otherwise what we do is we leave it to chance if we don't have a decision model that we can go by, some beginning point and factors that we consider. Family time really shouldn't vary depending on who the case manager is, who the judge is. It should vary only on the circumstances of the family. And all families should have an opportunity for the same time together, absent special circumstances. But that's not really what happened. It still doesn't happen because in some counties we have more than others. In some counties we have case managers who are really committed to making it happen. In some counties we have parents' attorneys who push to make it happen. And that's your responsibility too. When we're talking to parents' attorneys, that's another very large responsibility you have, is to push for family time, push for visitation, and use the reasonable efforts tool that we talked about earlier to help drive that. And we developed a decision model we'll talk about in a little while. These are our core principles. We ask early on that when we exercise this tremendous state power, what do we owe children, what do we owe families? And when we remove children from their homes, we have a legal responsibility to provide meaningful and safe visitation. That's not just a moral responsibility, it's a legal responsibility. A core principle is that there's a value in having a beginning point in the decision-making process that's research-based. And that family time should be based on the unique facts of each case, allowing for variation from the default provisions where certain factors of special circumstances are present. And although it's generally true that what's good for the parents is good for the child, where there is a conflict in those two things, those two tensions, then the child's interest always trumps. A foundational principle, a core principle, is that family time, an initial opportunity for family time, should be made available no later than 5 working days following physical removal of the child from the home. Because, sometimes what we saw was it could be a month before the children saw their parents, and the parents saw their children. And we thought that's just not acceptable. They need to be seen within 5 days. And as we present this, the question is asked, well, when they see one another at the 72-hour hearing, does that count? No, it doesn't count. It doesn't count. But it's a good question. Because what we do in our county to make that happen on a lot of cases is we will set up family time following the 72-hour hearing. Sometimes that works good, sometimes not, depending on the state of mind of the parents and the children. I'll tell you another piece of this, too, is that as part of a related piece, as part of our Operation Home Team, as a stakeholder group, we made the decision that the children having a voice in their case from the beginning all the way through was so important that they should be, children certainly 6 and older, should be present, not necessarily in the hearing, but at the 72-hour hearing. So we set time aside prior to the hearing, and we have a staff member there from CASA. We have the child's attorney there, and they meet with the child prior to the hearing. Oftentimes beforehand. If a child's pulled on Friday, normally that's when they first see the child. If a child is pulled on Monday, they may go out Monday afternoon or Tuesday and see the child. But no later than prior to the hearing, the attorney and the staff member from CASA meet with the child and talk to the child about the process and what's going on. They assure the child that the child's going to have a consistent voice throughout the process. So we made the decision that this was so important that we would get the children out of school for that, if it was a school day. So we had the children out of school anyway. We have our hearings in the afternoon, and then we have family time arranged, not immediately following, but after some cooling off time, and we have off-site, not at the courthouse, we have off-site family time planned for them so they can spend some time together. That's the way we meet the 5-day requirement in cases where they're pulled through an emergency removal. And within 30 to 45 days following removal from the home, if the child remains in care, the agency should develop a more case-specific family time plan, taking into account all the facts they've gathered or things they've learned since the child came into care. Now, since we require this family time to be part of the 30-day case plan, then it's in the 30-day case plan anyway. We'll talk in more detail about that later. Also, as part of the core principle is that the family time plan should be developed in the case seeking input from the parents, the child, the CASA, and other or child advocate, or both. We have a child advocate and a CASA in every case. Attorney child advocate and a CASA in every case. Whenever possible, involvement of parents and the foster parents together in the development of the family time plan is important. We may talk later about how that helped us roll out this protocol. Throughout the life of the case, circumstances change and facts become known that previously had not been considered in developing the family time plan. We need to be responsive to that. This is an important core principle. Family time plans should never be used as a threat or form of discipline of the child or to control or punish the parent. And we see that a lot. We'll see a rule in a group home that says if a child violates a curfew, gets a referral at school, they can't visit this weekend with their parents. And we'd agree as a stakeholder group totally that should never be the case. Anybody argue with that? Anybody want to argue with it? The next thing as an example is we agreed as a stakeholder group, as a group developing the protocol, that if mom fails a drug test, she should not be denied visitation because she failed a drug test. You guys okay with that? I hear a no? Got a no back there in the back. Microphone, Chris? I want more than a no, I want a response.
No, I don't think that the parents should have visitation if they test positive for drugs, especially if that's one of the main reasons that the child was removed. I mean, the concern is whether or not this parent will be adequately able to meet the child's needs on their own. So if they can't even stay drug-free in order to have visitation with the child, that does raise a concern about their ability to parent.
Certainly a view, and I respect that. Some other people may share the views, just didn't raise their hand. Other comments on that? Well, and again, every case is unique. We got a comment? Good. Good.
I would think that the whole goal of visitation would be positive, appropriate interaction, and there may be concerns if they're using and if they're testing positive that it won't be positive, appropriate interaction for the child. It may be more harmful for the child to see their parent in that condition, even if it's supervised. Do you know what I mean? So you got to think about what the best interest of the child in visitation as well.
Right behind.
But a positive drug test doesn't necessarily mean that the parent is currently under the influence. They could have smoked a joint 25 days ago.
Yeah,
So there's really no point in punishing the child by withholding visitation.
Exactly. That's one good point. Is we were really punishing the child, number one, not just the parents. But it was really a trick question of sorts because it called for kind of a yes or no answer. And as I was about to say, every case is different, every circumstance is different, every visitation is different. And marijuana does stay in the system for a long period of time. If Mom smoked dope on Monday, she's not under the influence of drugs on Saturday when the visitation is supposed to take place, then we believed as a group that she should be allowed to visit. If Mom shows up impaired, she shouldn't, and we understand that. If she scored high enough on cocaine on a drug test on Friday afternoon that indicated there was a lot in her system at that time, maybe she shouldn't on Saturday. Absolutely, child safety is still the most important thing. But the next important thing is maintain that family connection behind safety. And we have to make decisions. The point is we shouldn't have any absolute rules, but they're out there. They're out there. And the drug screening is a big part of those. It could be other things. We could say, Mom didn't visit last Saturday, so she can't visit this Saturday. If Mom misses 3 times in a row, we got to have a talk. You know what I mean? Because that's also harmful to the children, because the children expect that visitation. And one thing we know about most of our children is no matter what the parents have done or not done to them or not done for them, no matter what the circumstances were, they love their parents and they want to be with their parents, even when they're mad at them. We also know that when they can't see their parents, they worry themselves terribly over what is going on with their parents, and they are more likely to blame themselves for their removal. There are a lot of things we know about it that suggest that we need to promote this contact. Family time decisions are not made in a vacuum, so decisions regarding family time need to be made with consideration given to where the child is placed. And that's not just geographically. There are a lot of other things that come into play with that. We'll talk about them later. And we did agree as a stakeholder group, and I was so proud of us for agreeing on this, is that the failure to provide meaningful family time for children removed by the state action early and throughout the life of the case may constitute a failure to make reasonable efforts to reunify the families or effect and finalize an alternative permanency plan. It definitely is a reasonable efforts issue, as we talked about in the first session. Now, we did decide that we called them default provisions. Again, we couldn't agree on aspirational guidelines. We couldn't agree on minimum standards, so we called them default provisions. It's like so many other things that as a beginning point, we default to the starting point. This is our starting point, and that's all it is a starting point. It's kind of a minimum starting point as we talk about it. But we call these default provisions, and they focus on duration and frequency. They contemplate only supervised visitation at this point in the project. And I put in parentheses originally because that's one of the things we changed after the protocol was developed. And that this would contemplate only supervised visitation. The point being that we're trying to make is that when you can allow unsupervised visitation at some point in the case, you really should have more time together. If for no other reason, because it takes fewer resources to make it happen. You're eliminating some of the barriers to frequent and long family time periods when you eliminate the requirement for supervision. Now, I'll tell you so you can be thinking about it. What we did in Troup County is we turned it upside down. And there's a presumption in Troup County that all visitation should be unsupervised. We'll talk about that in a little bit. And they're driven by the needs of the children and families, not controlled by readily available resources, but influenced by an overlay of reasonableness. Okay? There's no excuse for not meeting these default provisions we're going to talk about. And we're going to be challenged on that in the coming months and years, probably because of budget constraints. We implemented this when there was more money to go around than there is now. We also, at the time we first implemented this, had well over 200 children in care. And now we have around 50 children in care, 53 as of last count. So obviously it's easier to implement this the fewer kids you have in care. So it's kind of a dual challenge, is let's work hard to safely reduce the number of kids in care while we're also providing more visitation for our families. And this works when reunification is the permanency goal. I mean, actually, one of the special circumstances is if reunification is not the goal, you might not need this much family time and this frequent of family time. It just depends. So the model is developed when reunification is the permanency goal. Now, this is our protocol, which tracks the protocol with the exceptions I'll go over. Again, we provide meaningful and safe family time, but also this is not intended to be a limitation. This is a minimum standard. And the agency shall provide as much family time as possible consistent with the needs of the child. We've talked all day about the fact that every case is unique, and family time is the same way. Family time plans should be based on the unique facts of each case, and then vary from those when we have special circumstances. However, under our protocol, when there is a variance, and this is the big protocol, when there is a variance from the default provisions that result in less family time, the reason for the variance should be articulated to all relevant parties to the case, factually based and appropriately documented and approved by the court. So yes, we can provide less than default provisions, but if we do, we have to meet this standard. Got to articulate a reason to all the parties. It's got to be factually based, not just on speculation or supposition, documented, and the court has to approve it. Now, in emergency circumstances, the department is authorized to cut off or reduce the family time. They have to notify the court in writing. We hold a hearing almost immediately, certainly within 2 weeks. And again, court time is easier to find when you have 25% of the kids in care that you had 2 years ago. We've already talked about in the best interest of the child trumps when there's a conflict. We've already talked about the need with 5 days, having the initial family time. Now, at the shelter care hearing, we addressed the issue of family time, and we develop a family time plan at the shelter care hearing to last us till I approve the case plan report, which has the family time plan in it, the full family time plan in it. And until we get to the subsequent hearings, they have to provide the minimum family time. And this is all well communicated to all case managers, supervisors, and every time we have a hearing or review, we talk about family time to ensure it's being provided in accordance with the plan and to consider if it needs to be revised. Now, this is what we did in Troup County. It was never written anywhere that all visitation is supervised, but it was. It might as well have been in a court order. It might as well have been policy. It might as well have been law. Because in every case, we had supervised visitation. in every single case. And we didn't think that was always appropriate, certainly for the life of the case. And there was no system in place to change it. You get way in the case, we still have supervised visitation. So we turned it upside down, and we have a presumption that all visitation is unsupervised up front. That's a rebuttable presumption. But what it makes us do is look at every individual case and decide if that's appropriate in that case. And I haven't kept the statistics, maybe we should have, but I suspect, just intuitively, that somewhere around 60 to 70% of our cases, we still have supervised visitation when we leave the hearing. But we feel pretty good about it because we made the decision after hearing evidence and after talking about it and having a discussion about it, that that's what best serves this family. That we've got to keep the children safe. Safety is an issue, and we've got to have supervised visitation. Another thing it does for us is it frees up resources by having unsupervised visitation in those other cases. Okay? So that we can help meet these default provisions, these standards. In our county, we really consider them to be standards. We expect to meet those. So it frees up resources. That's an additional benefit of it. Now, does anyone want to question whether, this is a wrong way to do business? Having even 25, 30% of your cases up front being unsupervised? After all, we just took the children out of the home, right? They got to be at risk. Are you itching to say something? Hold on one second.
What kind of things are you looking at with the presumption? What kind of evidence do you want at the 72-hour hearing that would convince you, you're just new in the case, that it would be safe, that they wouldn't leave with the children, and that the children would be safe if they're out of the home now?
Leaving with the children, I'll tell you, I don't have a problem with folks leaving with my children. They just don't leave with them much. That doesn't. Maybe it should be on my mind more. Maybe in your jurisdictions, you have folks, leaving with the kids more often. But we don't see it as a big issue, although it's a legitimate concern. But the safety definitely is a concern. And there's an issue that if we just took the children away from the parents because the children are at risk, so how can we trust them at all with their kids? And number one, we have good hearings. And we know a lot about the case. And we've gone eyeball to eyeball with mom and dad. In some cases, we've had a mental health assessment or substance abuse assessment prior to the 72-hour hearing. So we know a lot more about it at that point. And we just make a decision based on what we know and hear. The question at that point is not whether the child can go back home, although we should ask that question at every hearing and every review. But that's not the question we're talking about here. The question is, can we trust mom in the park for 3 hours with the children? And a lot of these, children are removed a lot of times. We don't have available resources because they've been living in cars and living here and there, and they don't have heat, or children are still removed for that reason sometimes. And that's not a real issue for 3 hours in the park. Another thing that we've done is involve families earlier, not just at the family team meeting, but even before that. And we have family members that say, I'll facilitate it, I'll be. That's not really supervised visitation, it's facilitated visitation. So we ask the questions and we know more about it. We've gone eyeball to eyeball with the parents and the children. We look at ages of the children. That's a big issue too, the age of the child. And before, it didn't matter how old they were. If they were in foster care, it was supervised visitation. And we just make those decisions. It frees up resources, and we think we're serving these families better and making individualized decisions for these families. And as with the general protocol, we have the case plans filed within 30 days. They filed with a more specific plan, then we review those. The family time plan should be developed in a family conference with as many of the following participants present and/or consultant. We have all those people listed there. It's just about everybody that could have something to do with the case. We wrote this long before family team meetings. We wrote this certainly long before family team meetings became law, which they are now. And we were bringing as many folks as we could together to try to help develop not just the family time plan, but the case plans. I say we, this is not me, this is the agency. And they bring folks in and they involve relatives and neighbors and their best friend, the child's best friends, parents, whoever they can involve, like we're supposed to in helping facilitate, decide the visitations and helping facilitate them. Whenever possible, the parents and the foster parents should be involved in the development and implementation of the family time plan. Thank God for foster parents. And we have foster parents that support visitation. We have foster parents that provide transportation for visitation. We have foster parents that allow mom into their home to spend time with their children. And this is even in foster adopt cases. Not in every case, but we have some that do that, and that is absolutely wonderful that they do that. So we involve them as much as we can. Those that want to be involved. Some foster parents do not want to be involved at all. I've done this presentation to foster parents, Jekyll as well, and that's kind of fun too. Some of them have an entirely different view about family time. The family time plan should not be rigid, but should allow sufficient flexibility for changes as circumstances warrant. Again, ensure safety. Safety is always paramount. And we talked earlier about if we change the family plan, there's got to be some due process safeguards in place. And it is a due process issue. Think about that now, because the parents are entitled by law to meaningful visitation with their children. That's in the statute. And when you do anything that suggests that it's less than that, that's a due process issue. We're taking a right away from them that they have to have meaningful visitation, and it triggers due process considerations. Talked about that one. Let me tell you too, I don't know if it's in the slide, but one way we do this too is we review, under our Operation Home Team, which I'll be glad to share with anybody that wants it too. It's a front-loading program that we have. Then we set an initial review hearing 45 to 60 days following physical removal from the home. And at that initial review hearing, I review in court with everybody there, I talked about that earlier, the case plan, the relative search, the milestones, we're going to talk about in a few minutes, the family time plan, and actually conduct the initial review, periodic review, required by federal law. And then we do panel reviews in 4-month intervals after that. So I actually conduct the initial periodic review even though I have panels to do it. So we're in court reviewing this family time plan within 45 to 60 days. And I know a lot more then than I knew early on in the case as well. And we can tweak that as needed in court with everybody there. All right. Shoot, I don't want to show you that. Child development psychologist. Do we have one in here? Infants. Let me just say first that we talked about this being research-based. And so what we were told by the developmental psychologist is that the only thing that children have in common, all children have in common, is age. They're all some age, of whatever it may be. And there's a lot of science around the ages of children. So we developed a protocol around these increments of age that the child psychologists say are appropriate from a developmental standpoint. So we start with infants. Let's talk about infants. From a developmental standpoint, how often do infants and parents need to see one another? For whoever's benefit, forget attachment, bonding, and all that kind of stuff. For whoever's benefit, how often do they need to see one another? As a daily? You think that's what the professionals say, the psychologists say? Anybody else have any ideas? He's right. And this is the tension that we had in the room, because the person that we brought in to educate us says they need to see one another every single day. Every single day. They also told us that at that age, frequency is more important than duration. The duration wasn't all that important. Frequency was, every single day. Well, I got all these folks in there, including a lot of defects folks, good people. They're not going to greet every day, and as good a job as my county has done, we probably couldn't have met that as a default provision. From day 1 of the case or day 5 of the case. We couldn't have done that. I don't want to use the term compromise, but we found some middle ground that the developmental psychologist also agreed was appropriate given the circumstances. And this is the middle ground that we found for them. And it's age birth to 6 months is 30 to 60 minutes a day, 3 times a week. Okay with everybody? I think that should be, at a minimum, what constitutes meaningful visitation. I mean, if the experts tell us that this is what children need to develop appropriately and what parents need to I think they bond and kids attach, whichever way it goes, then how can that not be the minimum standard? If that's as low as we could get a child psychologist to go 3 times a week, is anything less meaningful? Or we're spinning our wheels, hurting children, confusing children, parents. I don't see how legally, to me, this should be a legal standard. If this is what the experts say is the floor, that should be the legal standard. That's just me. There's not a case out there that says that I know of. Age 6 to 18 months, 1 hour 3 times per week. At this point, the frequency is still important, but duration becomes more important than it was for the children birth to 6 months. They need more time together, but they still need the frequency. Everybody okay with that? Age 18 months to 3 years, 1.5 hours 2 times per week. We're at the point now where duration, if you're balancing them out, duration becomes more important than frequencies. Kids can do without us for a little bit longer, but we need more time together to develop the way we need to develop in a relationship. Still not much time when you think about it. I mean, if that's all you got to see somebody you were courting, you'd probably never get married. I mean, how can you develop a relationship with just this much time? I don't know. Maybe some marriages work better that way. Age 3 years to 5 years, 2 or more hours, 1 time per week. I'm not crazy about the 1 time per week, but what we're told as a group is that, again, duration becomes more important than frequency. And if we're looking at default provisions, that this is appropriate, 2 or more hours per time per week. And again, those hours shouldn't be spent, sitting in a sterile environment, staring at one another, trying to think of something to talk about. It should be as much of a family environment as we can create. Let families be families to the extent we possibly can. Age 5 to 12 years, 2 or more hours, 1 time per week. Again, we got the same deal there in that developmental age. Then 2 hours, the duration is important, the frequency not as important. So this is what we should have. Now keep in mind, we should also have phone calls, letters, other contacts in addition to these to support these face-to-face times. Age 12 to 18 years, no specific recommendation. Now why is that? Must be dead. If I got to stay back here, I'll stay here. Yeah, I'm good. We don't have long left. I'll try to stay here. The children have activities. They have a say in it. So what else? The kind of way I look at it, some of you are pretty young, and some of you might be old enough to have had some teenagers. I'm not sure. But when you get up to 12 to 18 years and you live in the same household, getting a little bit of time with your kids is pretty tough in the same household. Kids have activities, they have their own mindset, they have their own friends, they have their own life. Certainly when you get closer to the 18. And we just couldn't come up with anything that worked. The notion was, and it's in the report, that in this age frame, really more important than having minimum amounts of time together during a week is being involved in their lives. So that you're at their ball games, you're at their plays, you show up at the school, you do those kinds of things with your children. It's more important, really, than having set periods of time. And that's the position that we reached. And I think that's pretty solid, based on what I know about teenagers anyway. We talked about special circumstances. Safety is always one, of course. Special facts in any given case, the permanency plan for the child, we talked about that earlier. As the permanency plan changes, we may have a reunification case, but if we move towards TPR and adoption becomes our permanency option for the child, it changes our view of family time. The existence of a concurrent plan is another fact, special circumstance we have to consider. Participation of siblings, including adults and children. Let's talk about sibling visitation in a minute, because somebody asks questions a lot of times that when we have, say we have a 3-year-old and we have a 9-year-old, then what do we have to do? Give the 9's time and the 3's time? And what we decided, number one, was that we got it put together anyway. Let's let the family be a family as much as they can. So other than maybe the older child having activities, if we have an infant or a child up to 18 months and we have 3 times a week, let's have the whole family together 3 times a week. No reason not to, unless an older child has activities. But one exception that we talked about, this I think makes a lot of sense. Say that we have an 11-year-old, just say a little girl, 11-year-old little girl, and we have maybe a 7-year-old, and we have a 2-year-old. Obviously, the 9-year-old, the 11-year-old child is not entitled to as much family time as the infant child. And actually, sometimes we don't want her there. Why do you think we might not want that 11-year-old there? Pardon? The mother may pay more attention to the younger child. 11-year-old may parent the 2-year-old. And that's, both of those are good answers. And we thought about that and we talked about that, and it's come up in application of the protocol. The 11-year-old has always parented the children when they were living together as a family unit. And we want to see what mom does with that infant child, not what the 11-year-old does. I had a case of three children, 2 girls and a boy, who had been in group home for a long time. Together, actually, but they've been in group home for a long time and doing well in the group home. And we had an opportunity to move them out to a relative. And the 2 younger children, they were all teenagers. The 2 younger children were very excited about it. And the older child didn't want to go. So I met with them in chambers and we talked about it. And they were upset with her about not wanting to go home with them. And she told them, I've raised y'all all my life. And I have my life now. I raised you at home, I'm raising you here. And I want my own life, and I don't want to go back home. It's kind of the same sense of it, but we've had an older child who really is parenting the younger children. We want to see what mom does with the children. So that's why we talked about it. These are the kinds of things we have to talk about in every individual case. The presence of domestic violence, that presents us a whole range of issues of family time. Whether the child is the victim or the parent is the victim of family violence. Schedules and activities of the children, schedules and activities of the parents. Relationship between the child and the current caregiver. That's an important consideration. The relationship between the child and the parents before removal. I mean, you know, you can have a child who had no relationship with mom before the removal. And sometimes we've got to maybe shorten the times of this family contact until we do some work with them. The child individually a lot of times before we can even work with mom and the child together to try to, in many cases, build, not rebuild the relationship. Transportation is a huge issue. And that's the question is, if my child welfare administrator were here and certainly if we had any agency people here, then they would ask the question, how did you do it? And they overspent their money. They overspent their transportation money for a considerable period of time. And they took the heat, as they should have. And their response was, we believe that this is our legal responsibility to these children, that if we don't meet this obligation, we're not providing meaningful visitation. And they did it, and they got by with it. And over time, we found ways to involve relatives more, to involve foster parents more, to reunite families, and we got it down to more manageable cost. That's one of the things that will be more difficult now because of the cost of transportation. A lot of that's been cut out or will be cut out. But you got to try to find ways to do it. Can't be blamed for trying and failing. You can only be blamed for not trying. There are other existing court orders. As an example, there may be a protective order out there that says that a parent can't be around the other parent or the child. Location of the parent, and the history of the parent's exercise of parenting time are all factors that are special circumstances. We talked about sibling visitation earlier. We all know how important that is. Many times, our children, although they want to see their parents, are more excited about seeing their siblings than the parents. But certainly they want to see their siblings in most cases. Now, under our local protocol, in any case where reunification is still the permanency plan in the case and supervised visitation is still required 6 months following physical removal of the child from the home, a hearing should be held at the first available date to determine if the permanency plan is still appropriate. If you're 6 months into your case and you can't trust mom with the kids for 3 hours at the mall or at the park, you probably don't have a good reunification case. you probably need to be looking at doing something else. If you've done a good job of case planning and implementation, and you still can't put them together for 3 hours somewhere without somebody observing to make sure the child is safe, it's probably not a reunification case. I'm not saying it's not, but I'm saying you should have court review of it to make sure that's still the appropriate permanency option for the child. And that's what we do in our court. And before the panel was handling that, because the panel was seeing these cases in the 4th month. Now they see the case the first time in the 6th month. I see them 45 to 60 days out, so I generally have a better idea at that point whether we need to actually revisit the permanency plan even that early in the case, particularly if we don't have a concurrent plan. If we're 45 to 60 days in the case and we've got everybody in the room and we know everything about the case like we should really have a pretty good idea about whether we need a concurrent plan or not. That's the latest date we should know, really, that early in the case, except in unusual circumstances. I want to talk about milestones. This was not part of the larger protocol. It's in the Troup County protocol. I think it's written up in the larger protocol, but it's noted to be a Troup County innovation and not approved by the larger group. Kind of goes back to our problem-solving model, too, where we talked about rewarding folks along the way, recognizing success and celebrating success along the way, and giving rewards along the way. I have to be careful I say that because you're going to challenge me on it, and I'll talk about that in just a minute. But we believed that we should develop a family time plan up front that provided for when we were going to expand visitation. If we had supervised visitation, at what point, assuming the parents comply with the case plan, are we going to move to unsupervised visitation? At what point are we going to overnight visitation? And at what point are we going to a trial visit? And at what point are the children going home? And that started out as a family time plan. Now, I will tell you that it has become a separate permanency planning tool and one of the best I've ever seen. And that's why I review it separately at my initial review hearing. Because we know up front, everybody knows up front, it's in shines, and it's approved by the court-ordered case plan, that says that if the parents are in compliance with the case plan, this is how we're going to move the child home. This is the true roadmap home for the children with those time frames in there. We don't have to wait for somebody to think about it. Well, is it time? You know? Now, when that time comes, we still need to take a look and say, was this the correct projection? Or should it be changed? But there's a roadmap with specific time frames for when we move to one thing to another and eventually to get the children back home. Now, what you may challenge me on if we had time for questions and we're getting short, and I also don't take questions good here, I can't even hardly see it from here, but is that by doing that, are we rewarding the parents for complying with their case plan? And if so, is that a proper way to reward them? If as they comply with their case plan, we give them more and more time together. It is a reward, but that's an incidental benefit of the protocol. What we're doing is we're recognizing up front that if the parents are in compliance with the case plan at these intervals, then the safety changes, the risk is reduced, and the child can spend more and more time with their parents safely. And that's the basis of it. It was not intended to be a reward, although it does have that effect. I mean, if parents don't know up front, if they think up front they've got to go 9, 12 months to comply with the case plan before they can get any real benefit from it, they're less motivated to work their case plan. Now, does anybody want to speak to that or ask a question about that? Again, I would encourage you to do that in your case plans up front, both as a family time plan component, but also as a separate permanency planning tool. A few minutes for questions. I do want to, of course, thank the Jim Anderson. Jim Anderson is a retired SAG. They don't call him that in New Hampshire, but he worked for Judge Sue Carbon. He was a former juvenile court judge, former president of the National Council, but also was just confirmed by the Senate as the new director of the Office of Violence Against Women, and has actually found an apartment last week in D.C. But he worked for her, and he's retired to Savannah, Georgia, and was looking for some things to do. So when I started doing a lot of work and research on reasonable efforts, he's done a tremendous amount of research for me, and I'm grateful for that. I've learned also an awful lot from the folks in Georgia and from the National Council in this area, and in presentations like this, both sitting out there and standing up here. So as we wrap up, we've got about 5 minutes. We don't have to take them, but if you have questions or comments, I would be delighted to take those.
You mentioned the minimum standards when we talked about getting reunification. And you made the comment that we don't like those, but that's sort of the term we have. And then later you talk about best interests of the child. Where do those two come into, where do those meet?
Yes, tough questions. Because, again, I don't want to use the term compromise, but if we're really told that infant children in particular, need to see their parents every day, then it's hard to say that we're really meeting the best interest of the children by providing something less. But what we looked at here is what we thought would be default provisions that would fit with legal requirements, that would be meaningful, not necessarily best interest. The default provisions did not serve the best interest of children. I would tell you that. The best interest of children are served in reunification cases in particular when you can spend as much time together as possible. But we feel like the default provisions meet the minimum standards, meet the legal requirements for meaningful visitation. I don't know if that answers your question or not, but they're distinctively different. The default provisions and best interest are not the same thing. The default provisions were built around what we thought would meet the legal standard for meaningful visitation. Anything less would not be even meaningful, much less serving the children's best interest.
That prompts a follow-up question then.
Right.
If reunification is having problems, at what point is the best interest of the child say we don't reunify?
Say that again, Jim.
In other words, if reunification is dragging out, and this gets back into my time tension model, that best interest of the child would be to say, I can't have a relationship with Mom, but I can have a relationship with my foster family if you'll cut the cord and let me be permanents there. So where in that continuum, the AFSA speaks to 1522. I know South Carolina says grounds for termination are, one of the grounds is in foster care for 15 months. So just the passage of time. But that seems to be, again, where that tension of the best interest of the child. I don't have a relationship with my birth mother because I was removed at birth. I can't seem to get one because she won't show up, this, that, and the next thing. How long before the child's right, and I guess I'm saying the child's attorney would be the one I'm speaking from, says to the court, stop this process. That's where I'm wondering where this continuum, and what signals go off that give you a sign, or I guess no one has that perfect vision. I don't expect you to either, Michael.
Good. And you know me long enough to know the answer. The answer is going to be, it depends on the facts in each individual case. Some people would tell you that once we choose to change a permanency option to TPR, and certainly once the TPR is filed, we shouldn't visit anymore. I would suggest that's probably not consistent with the law, because meaningful visitation is a requirement of the law that we provide it. Now, meaningful varies in each case. And in some cases, by the time you change your permanency option to go to TPR, in that case, then one of the special circumstances to be considered in here is the permanency plan. And you change the permanency plan, and that should be revisited. In particular, the child does not want, if it's an older child in particular, that does not want the visitation. So, yes, ma'am.
I guess I had two comments. First, on the family time milestones. I think that's fantastic. Like, what a great idea. I think we see a lot of cases, especially addiction issues, where when there's not a benefit, it's hard to continue on a case plan. I got really excited about that. And secondly, on the visitation, we operate a supervised visitation program, the agency I work for, and we've found a great balance between doing unsupervised visits once or twice a week and then one with our program so that there's still someone there, and that's been a great solution for our area.
And another good thing about that is, even though the visitation may not need to be supervised, then the fact it's observed is beneficial to everyone in the decision-making process, and you get feedback about how that family time went. So that's also very important. I would say one unintended consequence of the work we've done in family time and in reducing the number of kids in care is we've just about put our visitation center out of business, which is unfortunate. at this point, because we only have one child visiting at the visitation center at this point. So we're looking at other ways to utilize those resources. So. I'll take one more, and then I've got to wrap it up. Some of you guys want to beat traffic, if you can do that up here.
Okay, I'll try to be very clear about this question. And as it relates to 4E funding, does a reasonable efforts finding need to be made at every hearing? For example, if you had a reasonable efforts finding at the adjudicatory hearing, would you put that 4E funding in jeopardy if one was not found at the disposition hearing?
Good. Chris, we have an answer right here for that question, because I have one that may not be right. I'll tell you mine, but
12 months. It just needs to be every 12 months.
She's a SAG. What the SAGs will tell you is it has to be done every 12 months for 4E funding. I don't know of any prohibition against doing it in intervening hearings. And the Georgia law requires us to review the case plan at every hearing and review. Every hearing review is what and that's part of the case plan. So I think that gives us the authority, certainly in Georgia, to make that finding. And I think if we make the finding in the interim, then we can make that finding and it has effect. It doesn't make sense to me, and I don't think Congress intended, that we would wait until 12 months had passed before we exercise this kind of oversight relative to the agency's reasonable efforts. I think the court can make that finding at any time and affect 4E funding. But I've never been challenged on it. That's my view. That's my practice. I would welcome a challenge if anybody wants to make it. Oh. This really is the last question. I was just teasing last time.
Is it possible to raise a reasonable efforts argument at TPR?
Is it possible to raise the reasonable
Or
efforts?
is it already
argument
too late when you come to the TPR hearing to raise the issue that reasonable efforts have not been made?
Well, I'm going to answer that in two ways. I don't know that it's too late, because if the court TPRs, you still have 4E funding that's going to be paying for that child in foster care, so you still have the same issues. But it's certainly not too late to raise the question of whether it's appropriate to TPR if the agency has not provided services. And I have been there before. I've been at a TPR and made the determination that I'm not terminating rights because you've not given this family a fair chance to succeed. So those are two separate questions.
Please join me in thanking Judge Key for this
Thank you all.
wonderful presentation.